Joe Chirico. We're attorneys with the law firm of Murtha Kalina, and we're here today on behalf of the defendant matter, the town of Cromwell. Your Honor, the charitable use property exemption is a balance of public policy interests. On the one hand, when you're removing a whole property from the tax rolls, you're restricting the municipality's revenue and affecting their ability to provide essential services. You're requiring other local property owners to shoulder the burden of the exempt property owner. On the other hand, is our moral obligation as a society to support and encourage charitable organizations. And those are the policy issues that underlie 1281-7. But those are policy issues for the legislature. This appeal begins and ends with the statutory text. And that's particularly important because in this case, we're dealing with a property tax exemption statute. And a property tax exemption statute, under the unique rules of statutory construction that apply to them, require that the interpretations be strictly construed against the taxpayer and strictly construed in favor of the taxing authority. So in order for the town to prevail here, we need to show that our interpretation is plausible. Our view is that our interpretation is the most reasonable, but our interpretation need only be plausible because of those rules of statutory construction. Now, there are two phrases at issue here. The first is whether housing subsidized in whole or part by state government, and the second is the term temporary. Now, with respect to housing subsidized in whole and part of state government, I refer the court to our dictionary definitions of the term that are reproduced on page 10 of our brief. And effectively, we're dealing with housing here, something that provides shelter. And it doesn't seem like there would be any possible dispute that shelter is not being provided at 461 Main Street in Cromwell. With the issue of subsidy, there's no question. The only question then is whether the nonprofit entity is receiving government funds, receiving state funds that are being applied in any way to that housing. And that becomes housing subsidized in whole or part in the state, by state government. And let me start with why that's important. That's a subset of the types of nonprofits that are affected by this charitable use exemption. And I do see Justice Ecker has a question.
Thank you very much, counsel. Justice Ecker.
I believe Justice.
You may be muted.
Sorry, I keep doing that with my my hand, lowering my hand, but not raising my voice. So you may be a step ahead of me here, counsel. I'm having trouble finding that this is such a clear and unambiguous statute. Can you just explain to me what the idea was, or you think the idea was? Better if there's some legislative history to support you. What did the legislature have in mind here when it created this exemption or non-exemption for subsidized housing, low and moderate income housing, but not for those 5 categories in 7B, you know, the orphanages and facilities, the mental health treatment, addiction treatment? What did it have in mind? What was it trying to do? Do we know? What's the idea?
Sure. So let me start by saying again, I think again, the rules of statutory construction, we don't get into the legislative purpose or history because it's a statute construed against the taxpayer in favor of the taxpayer.
I know you think that, but
no,
get right to my question, if you don't mind. We don't have a lot of time.
And the answer, Justice Ecker, is I think the term you used was subsidized housing, but that's not what the statute says. The statute says housing subsidized in whole or part by state government. So let me start with that. Second, what they were dealing with, to the extent we look at the legislative history, are the different types of nonprofits that might be affected. For example, a nonprofit that is renting this facility from a private property owner, that property would always be subject to taxation. No dispute about that. A nonprofit that has the financial resources to own its own property and is operating strictly with private funds would also be the beneficiary of the exemption. No question about that. We're now talking about a subclass of nonprofits who have the financial resources to own their own property, but are also receiving subsidies from the state taxpayers. And that was a huge issue, Justice Ecker, in the 2003 legislation that put this principle in place. Why that was so
Well,
important.
what I don't understand is what like an orphanage, right? I mean, maybe I'm misreading it, but, subsidized or not, if it's an orphanage, if it's a drug, those are categories for temporary housing that just aren't subject to the tax, right?
Incorrect, Your Honor. If
Okay,
they are,
explain that.
so if the orphanage, we'll use the orphanage example, though it's not a great one because they're generally obsolete. But if the orphanage were privately funded and a nonprofit and owned by the nonprofit, they would be exempt. If the orphanage were leasing from a private property owner, it would not be exempt. If the property were
But these are nonprofits.
Yep,
These are all nonprofits, right? Rainbow and Gilead, they're nonprofits, and they're operating a facility for helping people with mental illness. So if it's temporary housing, they're exempted.
So
I'm trying to figure out why you would exempt for temporary, but not for something else. What's going on in the legislative mind?
So to that point, if the entity is receiving government funds, there was a dispute about whether that should be exempt because they're already receiving state aid. That was the dispute. And the compromise we look at is if it's going to be temporary, then it's going to fall into it. So to your answer, Justice Ecker, if an orphanage were to be receiving state funds, that's what triggers its application to Subpart B. If it's not receiving state funds, we're only in Subpart A of the statute, and they'd be exempt. Now we're talking about the universe of nonprofits who are relying on state funding. So now the question is, if you're relying on state funding, then it's got to be temporary. And the orphanage example that the other side uses is not a great one.
Mr. Lodas, I'm really sorry to interrupt, but we've been talking for about 3 or 4 minutes, and I haven't gotten any answer yet. Why does temporary matter in the legislative mind? I mean, it's used for housing. It's being subsidized by the government. But it's the legislature, for some reason, said, we're going to still exempt, if I'm understanding it right, we're going to still exempt these properties if it's temporary housing. Why did they explain can we make any sense of that?
Yeah, again, on the plain meaning, you would look at the plain meaning in the dictionary definitions. But the answer is the example that was given at the testimony before the legislature in 2003 was battered women's shelter. And they were looking at the facts. So this is one of the things they were saying is, okay, if this is something in order to fulfill its mission, where we need somebody to be able to stay for a night, stay for a week, stay for 30 days, we don't want to put that into the category of removing the entire property from the tax rolls. That was the context in which that came up. It was not in a situation where we were dealing with any kind of permanent, any type of long-term care, those types of facilities were not supposed to be exempt. And we know that from that discussion in the legislative history. Keep in mind, when we look at, obviously, one of the things that triggered this issue was the Isaiah case in 2004. 2003 is when it was pending, as well as the Bridgeport rescue, the Crosby case out of Bridgeport. And all of those, one of the things that they were testifying to is we need to be able, the housing that we're providing is temporary, meaning very short periods of time.
I got you. And this will be my last question. I'm sure other people have questions, but I still don't get why temporary matters. I mean, the municipality is still providing the same services. But the legislature decided that for some reason, if the turnover, if it's a temporary nature residence, for some reason that changes the focus. Maybe it means that the money is being provided for some purpose other than housing if it's only temporary. I don't know. But you gave me an example, domestic abuse, but you haven't told me, and maybe just because we don't know what the idea is. What's the principle?
And I guess, again, the idea was to make sure they weren't providing tax exemptions. We're talking about removing the entire property from the tax rolls for property that was being used for anything other than temporary. And the reason is I think it was a compromise to give some housing, benefit to some nonprofits that were using it for housing. So it wanted to be limited. And Justice Ecker, to this point, this is why I come back to my first point about why this should be dealt with as the legislature. This has been come up in the legislature 3 times since 2016, 2019, and most recently 2020, where the question about whether removing the word temporary should occur because they wanted to expand that determination to whether or not we should make a distinction between temporary and permanent. But again, Justice Ecker, the legislature is best suited to address it, and they indeed have been addressing it. They had hearings on it in 2016, hearings on it in 2019, likely would have had it in 2020 if we didn't have the pandemic. That's the form that should be addressing that. The only question we have is under the plain meaning of this statute, does it require a temporary stay? And the answer to that is explicitly by the statute, yes.
Mr. Das, Justice Khan has a question.
But as a follow-up to that, if you believe temporary is significant, how is temporary defined other than what you've told us that the legislature was thinking about housing for battered women? There are other types of housing. Doesn't it come down to what is temporary? And can temporary be more than 30 days? And does it really matter if it's housing for temporary for residents? Does it really matter as far as the town's concerned? Because they're not getting taxes whether person A or person B is using the room. So why should that matter? Just from a policy perspective, why should it matter to the town if it's temporary, whether the person is there 2 months, 3 months, 6 months, 30 days?
So, Justice Khan, it's again a policy question for the legislature. The answer is that we have a town assessor that has to apply a statute, and that statute requires that it has to be temporary if the entity is receiving government funds. And if you look at the application, because I think this will clarify it, on A202 of our appendix is the M3 application, and it specifically identifies on page A203 if the property is being used for housing, those subcategories that have to be asked about. And one of them is average length of stay. So there's no question that that is one of the criteria that has to be determined by the tax assessor. And the tax assessor doesn't get to change the statute. All the questions, this question Your Honor is asking, the questions Justice Ecker are asking, are questions for the legislature, and they're dealing with that.
But the issue is before us now, right? And so the town assessor presumably has to follow the intent of the legislature. And I think that's where I don't want to speak for Justice Ecker, but that's, I think, where our questions are driven. So if the town assessor has to interpret what the legislature meant, then it would seem to come down to what temporary means. And shouldn't we look at the legislative history? Then it doesn't become so clear. It is ambiguous, and we should look at what the purpose of these exemptions are.
So, yeah, the tax assessor is not charged with interpreting the statute, it's applying the statute. And so that's why we have to rely on...
But in applying the statute, they have to interpret.
And in applying the statute, they have to comply. What they have to do, to Your Honor, if you note, if you argue that it's ambiguous, they have to construe it against the taxpayer and favor the taxing authority, because tax exemptions are an act of legislative grace. And keep in mind that any time the tax assessor is trying to treat everybody fairly under the statute, they don't get to pick winners and losers. And the reality is that any time there's a property exempt from the tax rolls, it's gone from the tax rolls. Either services have to be reduced or other taxpayers in town have to shoulder that burden. And I think the legislature struck a great balance here, because by requiring entities that are being subsidized by the state, what they're doing is ensuring that any of these public good that's being provided by these charitable organizations, that's being shouldered by the taxpayers across the state of Connecticut, and not disproportionately in municipalities where these houses are located. That's the balance the legislature changed, and that's the debate that keeps coming up before the legislature. This is why these aren't in 2003, 2016, 2019. Those are the competing policy issues that the legislature is debating, but that's where that answer has to be. With this statute, it's not a normal statute. It's a tax exemption statute. We look at the plain words because that's all the tax assessor has to go to. The tax assessor does not dig into the legislative history. Legislative history supports us because it only talks about circumstances that are short term. Everything that was discussed before the legislature was short term. But that's not how this statute's interpreted by the Supreme Court, because the tax assessor is not supposed to dig in behind the plain meaning of the statute.
Justice Doria, and then Justice Mullins.
Thank you. Good morning. Okay, let's start with the assessor's form, which asks for average length of stay. That doesn't matter, right? I mean, that's the town's form. So how he or she construes the form, you're not looking for deference or anything. These are de novo trials.
Well, that's actually a statewide form, so it's not. I mean, it's the tax assessors put that together for everybody. So that's not something unique for the town of Cromwell.
Okay, but so whoever the author is of it, I mean, they're going to be bound by. I mean, average length of stay may or may not have anything to do with temporary. Maybe you're right. Well, I guess that leads to this question: how do we measure temporary? You say it's got to be of limited and specific duration. I buy the limited. That's sort of inherent in temporary. Specific, I don't know. The examples you have of statutes that give specific amounts of time, that's not here. We don't have 30 days. We don't have 6 months. So we have 5 residents. Maybe some of them stay for a long time. Maybe they've been there since 2006. Maybe some of them turn over every few months. So I don't know what the average length of stay would have anything to do with temporary. We have to give some construction to the term temporary. What guidance do you have for us? Yeah,
so I number one, the guidance I have is the dictionary definitions, because that's where we start, and those are produced on page 19 of our brief, and they do talk about a limited specified period of time in the dictionary definitions. I also look at the fact that generally, to your point, Justice Dioria, when we talk about temporary in the other statutes, there is a restriction on the period of time, just because in this case, they didn't necessarily say what it has to be. What they did say is maybe the renter and the housing authority can make an agreement about what temporary would be, and it would at least have some kind of period of time.
Well, okay, so now you're on summary judgment. I mean, without an amount of time, I think your opponent would contest whether you then look at the other statutes for what the period of time should be. Usually we fill gaps by saying a reasonable period of time, or in this case, you have summary judgment. Why isn't it enough that Mr. Osborne did an affidavit that says that this is intended to be temporary? Maybe you'd want to put into his proof or have some discovery about what actually goes on here. But I mean, at some point the burden shifts, or we look at the contract to say, what was the intent? The intent seems to be for temporary, as a layperson might construe it. What do you say to that?
I say you're exactly right. This shouldn't have been decided on summary judgment, and those facts should have been contested. Because if you look, and this actually raises.
But did you contest them?
We did. You did. Yeah.
You contested the temporary aspect of it on the point of not limited in duration. I mean, did you put evidence forward that contests his affidavit saying this is temporary?
So 2 things to that. Did we contest it? Absolutely. And it's very clear from the oral argument in the trial court transcript. We said there's no evidence that this is temporary, number 1. Number 2, let's keep in mind, one of the issues here is that the burden is on the property owner to show it's temporary. Number 3, and this goes to the town of Manchester's amicus brief. If you look at the M3 form, they never disclosed anything that would support a finding of temporary. So the question there is whether they'd be stopped from further asserting it. That's the argument Manchester is pointing out. But the point is the property owner has the duty to tell the tax assessor, this is temporary and here's my evidence of it. And number 4, Justice Dioria, to the point that we, again, not in the record, which is why we should be going back to trial on this, but we did look at the voter rolls, and at least 2 people living at that property have voted for the past 7 years in the elections. I think we found another one that voted the past 4 years. The reality is that this is an extreme example of what is not temporary. And none of that is before the trial court. The trial court never made factual findings on that of whether that would constitute temporary.
You're saying, I'm sorry, you're saying you found that maybe that's a matter of public record. Did you put that in the record?
If you look at our supplemental brief, footnote 7, you'll note that it is, but at the end of the day, we should at least be able to have evidence on that. So the reality is,
I mean, that's what summary judgment is somebody thinks they sustained their burden and you push back on it. And, maybe that would have been good evidence.
well, and Your Honor, if the only evidence we have here is a statement from Mr. Osborne saying this is transitional and temporary, and that's it, no length of stay, no evidence whatsoever, that's certainly not sufficient to say that there is not a dispute of fact about temporary, because below we did challenge that. And at the very least, to your point, we should be able to cross-examine on that. Because if you look at Your Honors, if you look at the other submissions that were made, including the policy manual, it says that these are for individuals that would otherwise be in long-term care. That's the language. It's contradictory to the own documents that were submitted. So there's no way to our view is this. If this was decided on summary judgment, then the town should have prevailed, because the burden is exclusively on the taxpayer and they did not provide sufficient evidence to establish facts to show that this is temporary. But if there is a question of fact about whether this is temporary, something that the trial court should have found, then it should have gone to trial. There's no way the trial court should have decided this case on summary judgment in favor of the taxpayer, because they didn't meet their burden of proof. And to that point, I want to come back to what the town of Manchester noted. All that information should have been provided to the tax assessor in the first instance, and that's the J.C. Penney case, because otherwise they're going to be stopped from asserting additional information before the trial court. So that's another issue that would have to be addressed, but those are all the problems with the trial court deciding this on summary judgment. The record simply doesn't support a finding of temporary, no matter how you define that term. And the other thing I note, Your Honor.
Justice Mullins' question. Thank you.
I think many of my questions were answered in your last colloquy with Justice Doria. But what I want, maybe to the extent they weren't, what I was curious about is this was summary judgment. And was Osborne's affidavit really the only basis to conclude that this was temporary? Exclusively.
There's literally no fact to even support that.
Okay. Well, let me ask you, because I heard you set it out and how this should go. They would need to meet their burden to show that it was temporary. If we disagreed with you and the court could conclude based on that affidavit that they at least met their initial burden, what was the counter evidence pushing back on that this wasn't temporary that you put in?
So, Your Honor, let me back up and say, because it's not the town's burden, we simply challenged that representation and said it's not temporary. And that at least is a disputed question of fact. So there was no burden on the municipality, and the basis for the municipality.
But before, I mean, and correct me if I'm wrong, but before, if they put in enough and you just say we don't think it's enough, that's not enough to overcome the hurdle that they've surmounted, right? I mean, it doesn't create the disputed issue of fact because they've met their burden and you just say they didn't. If they've met their burden, then there would have to be some evidence pushing back on that, right?
Yes and no. Because this is a tax appeal under these circumstances, we really start with what was before the assessor. So they're really not supposed to plug evidentiary gaps. So really, and that's the J.C. Penney issue, it should have been the end. They didn't produce evidence to the tax assessor of what the average length of stay is. But Justice Mullins, if they were able to, and the court were to say, we'll allow you to go ahead and produce additional evidence, it's only this affidavit. What cuts against that, and we pointed it out in our briefs below, is the fact is your own policy and procedures defined by Gilead. And that's one of the stipulated exhibits. And we pointed out to the trial judge that specifically says long-term institutional care is being substituted for by this program. So the term long-term is already used. We also noted, and we argued below, we have no idea when people are coming in and when they're going out. Again, we have certain ways of determining that it looks like all these stays for numerous years, which can't possibly be temporary. But as far as what's factually available to us, keep in mind, we kept asking for this information. They are the individuals that have all the information about what the length of stay is. They wouldn't give us that information. So all we can do is dispute it. And that's why we never received it despite us consistently asking for it. And that's one of the problems, was being able to say, oh, we're temporary, just take our word for it. That's really what's happened here. So if they were to sit there and produce this information, then we could try it to the judge, and the judge can make a finding whether it's temporary or not. Fine, that's a factual finding. But there's no basis for making a temporary determination on this record.
Can I, just one more question? I see others have questions on this point. And if I missed it, just, pardon my ignorance. What was the definition that the trial court was operating off of for temporary?
The trial court did not define temporary. What the trial court said is there's nothing in the record, there's nothing in the stipulated exhibits through which the town has proved that this is not temporary. So one of the issues you'll see, that's the entire analysis of the trial court. So if you look at that's one of our arguments, that number one, they had the burden for two reasons. One, because they succeeded on summary judgment. That it's one thing for the court not to grant summary judgment to the town. It was completely improper for the court to grant summary judgment for the plaintiffs, because the plaintiffs have the burden of proving it's temporary, not that the town has to prove it's not temporary, number one. Number two, that's not just because of the standard rules of summary judgment. That's true because of the nature of the statute we have here. The statute, again, is a property exemption statute. Therefore, the burden is exclusively on the taxpayer to present evidence, number one, to the assessor at that level to determine whether or not this is temporary. And number two, even if you were to say that they could produce additional evidence at the trial court, and J.C. Penney says otherwise, but if you were to say that you were produce additional evidence at the trial court, that burden is still on the taxpayer to make that showing. And there was no evidence, not one piece of evidence to show how long any resident resided. It was simply an aspirational goal that this would simply, that someone would someday leave this facility. And Justice Mullins, to take that to its logical conclusion, that means everyone living in an apartment that decides they may someday want to move is temporary in nature. And that's clearly not the meaning of the statute is. And to close on this temporary point, I want to make something very clear in our rules of statutory construction. 3 times the legislature has been confronted with the opportunity to change this statute. This issue about temporary keeps coming up before the legislature. They were asked in 2016 to remove the word. They didn't. They were asked in 2019 to remove the word. They didn't. In 2020, it was up again. It hasn't been removed. Obviously, it'll likely come up in 2021. Why would the word temporary need to be removed from the statute if the reading that this town and 40 other towns have given it is not accurate or at least plausible? And that is the standard that this court uses for a property tax exemption statute.
This isn't the reading the town has always given it, though, right? There's no reliance factor on the fact that they have accepted the exemption for a number of years, haven't they?
That's one of the claims the other side is making, because every 4 years the tax assessor has to assess whether or not the exemption applies. And this exemption was denied in 2017, along with a number of other municipalities. But there has been some debate about this. That's why in 2016, if you look at the AG's brief, they put in a footnote I believe 15 towns that have been addressing this issue in litigation. That dates back to 2015. So it looks like that's the year in which this kind of in clarity based on the number of different types of facilities we started seeing. I think the issue is, Justice Mullins, you've never seen a case like this where you have someone saying, hey, we fit temporary because we say so. We don't have any evidence to support it. And at the end of the day, the actual evidence is that the individuals are staying for years on end. Whether that qualifies as temporary, the court's never confronted that before. Isaiah House, which is from 2004, the trial court found no stay exceeded 6 months. Every other time you've had one of these types of facilities, it's always been clearly something that was temporary in nature, and at least, in that 3 to 6 months range. We haven't seen this before. And I think that's one of the reasons we're here at the Supreme Court. But I come back to the statute's got to be construed if there is an issue, if the word temporary needs to be removed, it's not for this court to rewrite the statute. It's for the legislature.
Thank you, Mr. Doss. Justice Kahn.
Thank you, Chief Justice Robinson. But it's not an issue of removal of the word temporary. It seems to be an issue of how you define temporary. And my concern is two questions. One for clarification, other than pointing to their own materials that indicate these services should be in lieu of long-term, to provide services for folks who would otherwise be in long-term care. Other than that, did you point to anything else to show the trial judge that there was a question of fact as to whether this was temporary housing or not?
Again, Your Honor, they didn't furnish any evidence to us.
Well, they furnished the affidavit, okay, and I know that's how you interpret it. That's not my question. My question is a simple one of the record. Other than pointing to their own materials, did you submit anything else? Yes,
Your Honor. Again, and this is the M3 application. On the M3 application, the town assessor, the reason for denial says, I don't know what's going on at the property. Her oath is to sit there and say, I can't speculate. So that's number one. Number two, their own materials, which flat out said that this is for long-term care.
I got their own materials. Mm-hmm. That's not my question. Okay, so now you've added one thing, the application they submitted. Was there anything else you pointed to the trial judge that would create an issue of fact as to whether this is temporary housing, other than their materials and other than the application?
Yeah, I mean, and the rental agreement and the housing agreement, which said that these folks are renting the property, and just the existence of it. Keep in mind, they wouldn't give us the leases. And Justice Kahn, that's the point. How can you challenge a party to provide evidence of what the other side is doing when they have all the information and refuse to disclose it? And this is why, as a policy matter, if you want to come back to policy, why the town of Manchester says in their amicus brief this is an estoppel issue, because you can't keep the material from the town assessor and then say, now you can't show we're doing what we're not saying we're doing here. That's fundamentally unfair, and that's why JCPenney holds what it does. Okay, so thank you for the answer to that question. My next question is this. You were equating this with someone just renting an apartment for 2, 3, 4, 5 years that becomes temporary. But isn't this fundamentally different? I mean, these are individuals who, are getting wraparound services, right? They're getting services just beyond the roof over their head, services on independent living, the goal of these facilities is to get people to a point where they can become like a regular renter renting an apartment. So if we accept your definition of temporary, and it's like throwing the towel in and saying that these services that are provided to get people where they can live independently on their own without wraparound services, that basically we should just say, no, these people will never accomplish that. And therefore they will, won't be temporary. I mean, the whole purpose of these programs, right, was to get people from situations where they're in long-term residential facilities to full independent living. So then the question becomes, where do you draw that line? Someone may need 2 years, someone may need 3, someone may need 6 months. So to suggest that they are like regular renters isn't quite right. And it's almost as if you're saying, well, if they need this level of care, then we should just assume they'll never live independently. So that's the wrong question, Your Honor, because you're asking a question that would go to the legislature about the policy and how best to implement it. Here's the question that's before you. Whether or not this statute requires payment of municipal taxes. Justice Kahn, every one of those things that you're discussing about the goodwill, and we don't acknowledge it in the reply brief, it's a laudable program. All of that, if this was privately owned and the facility were renting it, no question it would be subject to taxation. So if this was privately, if the charitable organization owned the property and was providing all these services without a state contract, no question that this would be subject to, would not be subject to taxation. We're talking about an entity that's receiving significant state financial resources. The representation they had is $12.5 million a year in order to provide this. And they didn't exempt that from taxation. I mean, so how do we know that the subsidy, okay, that you just referenced goes exclusively to housing versus going to the other services they provide, like staffing,
transportation to and from appointments, perhaps other services like mental health services, career counseling, all the other services that are given. So you're saying look at the subsidy and attribute that to just the roof over their heads. How do we define subsidy?
Mr. Chief Justice, I see I'm out of time. May I answer the question?
You may, Mr. Das.
Thank you, Your Honor. And Your Honor has raised exactly the point of why this couldn't have been decided on summary judgment. That is a fact question for the trial court to determine. If the nonprofit can show that the subsidies it's receiving from the government do not go to housing at all, they go exclusively to services, they'll come within the scope of the exemption, no question. But they have to make that showing. And in this case, on this record, they couldn't do so. We don't even have consistent statements about what percentage of the services are provided by state funding. The Osborne affidavit says 90%. Subsequently, the representation is 75%. If they have bookkeeping that can show us it's not allocated towards housing, absolutely, the legislature wanted that to get the exemption. But once it went to housing, it has to be temporary, and that's what the legislature has said. And the legislature wants to make sure that the municipality is not the one harmed, that they're able to provide essential services, that the local taxpayers don't shoulder the burden disproportionately to the rest of the state taxpayers that are benefiting from the organization's services. Unless there's any further questions, I may reserve the rest of my time for rebuttal, Your Honor.
Thank you, Mr. Das. Justice
Thank
Ecker,
you.
your hand is now lowered. Was your question answered?
I'm good, thanks.
Justice Daria?
I'm going to see if Attorney Naples takes up the question, the area I was going to inquire about, and I'll go on rebuttal if I need to.
Thank you very much, sir. Thank you, Mr. Das. Attorney Naples.
Good morning, Your Honors. May it please the court. My name is Pascal Naples, and I have the privilege of representing Rainbow Housing Corporation and Gilead Community Services Incorporated in this matter. Between 2006 and 2017, the town of Cromwell deemed Gilead's use of 461 Main Street to be tax exempt as charitable. Then, in 2017,
Naples, are you arguing some type of estoppel?
No, Your Honor. We're not arguing estoppel in this case. However, it is relevant that the two prior quadrennial applications that were filed by Rainbow and Gilead in this case were subsequently denied by the town of Cromwell despite no change in use of the property.
What does that have to do with this matter? It could have been done through error. It could have been done through a different interpretation that was corrected. And you're not arguing estoppel. So what relevance does it have to this matter?
Because as the town of Cromwell admits, and as the town of Manchester asserts in its amicus brief, the assessor has to use the best evidence before her available in attempting to assess the validity of a tax exemption. And here,
so how is this the best evidence?
Because part of that evidence is the prior two grants of a tax exemption in the property.
I don't understand how that's the best evidence, though, sir. I just said that it could be for many reasons that it was treated one way before. It could be a different assessor. But that's to me at best would create a question of fact.
That information,
and I don't think it rises to that level, to be honest.
That information alone, Your Honor, would not satisfy the burden of proof in this case. But that information in combination with the application that was provided, and that's at A30 of the appendix, that specified that the property was not used for housing and was used for mental health treatment, was sufficient to satisfy the burden of proof in the first instance for the assessor. The trial court.
Sorry, counsel. Justice Ecker?
Chief, are you finished with that line of questioning? Okay. So a couple questions just about what was argued in the trial court and what wasn't. And I confess I am not as familiar as should be with the briefs below. I just didn't look at them. But I guess, a couple questions. One is, was the argument made by the town below hey, no more evidence. You can't look at any other evidence or anything else. We're going to do this solely on the face of the application. Was that argument made by the town?
Yes. The town before the trial court asserted that there were no genuine disputes of material fact.
No, that's not my question. My question is, Mr. Doss, the town of Manchester, has made a number of arguments about, well, first of all, you shouldn't go beyond the face of the application, or words to that effect under the Penny case. Secondly, that there were disputed issues of fact relating to what temporary means, and there should have been a full trial. I'm trying to figure out whether those are arguments not being made for the first time on appeal, or whether the trial court was fairly confronted with them. As I understand the record, this was there was stipulations, joint submissions, cross motions for summary judgment, and from as far as I can tell, just on the surface of things, the trial court was told, look, this is an issue of law, judge. Please decide it based upon these submissions. Well, each side will make our submissions and then you decide the issue. Is that what happened? Or did the town say, oh, no, only on the face of the application, we want a trial. On the temporary issue, we want a trial and so forth. Can you answer that question?
Yes, Your Honor. Your initial read of the record is correct. There were no arguments by Cromwell in this case that there were genuine disputes of material fact before the trial court. Those arguments were raised for the first time before the appellate court and then in the briefs before this court, and therefore are not properly before this court, as this court, pursuant to its precedent, does not presume errors or grant issues or consider issues that were not properly raised in the first instance before the trial court. In addition, the evidence that was before the trial court was sufficient for that court to grant summary judgment, namely the affidavit of Dan Osborne, Gilead's executive director, which is available to this court at A278 and A279, the policy and procedure manual that Gilead implements at 461 Main Street at A276 and A277, and then the application initially submitted at A30. That evidence is sufficient for the trial court to grant summary judgment, especially when, again, before the trial court, Cromwell never argued that there were genuine disputes of material fact that should preclude the grant of summary judgment. Now,
Justice Acker, did you finish with your question?
Yes, thank you.
Counsel, was there anything in the record that your brother counsel said there was evidence in the record that disputes the proposition in the affidavit?
That's not accurate, Your Honor. The representations in the affidavit and in Gilead's program and procedural manual are consistent as to both the question of whether the property qualifies as subsidized housing and whether it qualifies as housing for mental health treatment. Namely, at A278, Dan Osborne's affidavit states that none of the residents receive occupational subsidies like Section 8 housing vouchers, and Gilead receives no housing subsidies at the property.
What about the issue of it being a long-term care situation for some of its occupants?
Whether it's a long-term care facility, Your Honor, does not necessarily mean that it's non-permanent.
You said not necessarily.
Sure. Well, the fact that the facility is long-term care for some does not mean that the property isn't transitional in nature. And that's the relevant inquiry for this.
The question is there a genuine issue of material fact? And it seems to be that you're using words that are not absolutes.
No, Your Honor, because all of the evidence in the record in both the program and the procedural manual at A277 and in Dan Osborne's affidavit at A279 say that the aim of the program is transitional, to allow patients to lead an optimum life in the community. And the definition of the word temporary and temporary housing can be temporary because it's temporary, because it's transitional, not simply because it is short-term in duration. That is a definition of the word temporary. And the legislature understood that And all this court needs to look at is the plain language. The fact that the legislature included temporary housing for those with mental illnesses specifically means that it understood the nature of mental health treatment. And the nature of mental health treatment is that it may be a few years, it may be a decade, but it is still transitional, and therefore it is temporary by design.
So a decade can be temporary.
Yes, Your Honor. Indeed, orphanages are specifically an example provided by the statute, and an individual may reside in an orphanage for a decade or longer.
Just a story.
Thanks. I'm going to change the subject just for a moment because I think you got enough time to get back to the other thing if that's where you're interested. I actually think that the housing subsidized issue is more challenging for you. And so I have this question. I'll confess that I'm a fiscal simpleton. Cash is fungible is basically all I know. So you're getting a big grant from the state. Now you say that this is the money that Demas provides pursuant to the contract does not lower residential occupancy costs. Well, how can we tell that? If you didn't get those grants or subsidies, why wouldn't it be fair to infer that the very low, you won't call them rent, they're the fees that you charge would have to be somewhat higher, or else I guess you wouldn't provide the services, or you could just close up. But how do we know, since the contract, sorry for the long question, the contract would permit you to use this money for housing? You don't dispute that, right? Unless your housing costs are so low, which I don't see anything in the record as to what that is, how do we know what that you qualify for this exemption if 3/4 of your is it just because it's only 3/4?
Your Honor, the relevant inquiry for this court is the design of the subsidy in the first instance and the way in which that subsidy is developed and then intended to be used and purposed for the organization. And here, the Demas subsidies at issue are specifically allocated toward mental health. That
based on what? This is based on what?
This is based on the contract.
But the contract says you can use it for housing. So, I mean, do you need proof, accounting proof, or your answer is going to be no, but you're allowed to use it for housing. You're just saying you didn't use it for housing, but what else is there besides the contract?
There's Gilead's program and procedural manual, which specifies that the property is being used for daily supervision of individuals' activities on a 24/7 basis for those with severe mental health illnesses. That's treatment, that's therapy, that's not simply shelter as would be provided at a subsidized housing, government-funded housing development, akin to those considered by the legislature in passing the 1975 amendment to the statute.
I mean, that seems a little bit closer. I mean, Mr. Doss would disagree with me saying this. It seems a little closer to what he's saying. It's because I say so. I mean, better evidence of that might be an auditor's report, saying, this is the Demas money went here. Or there weren't, but because there were no restrictions on how you spend the money. So I guess you may be right that if as long as you're not spending you're more than, if your housing costs, let me ask you it this way, I'm sorry. If your housing costs were more than, I did the math, $143,000 a year, you'd concede, but you were meeting your budget. You concede that you must have been using some of your Demas money for housing.
Your Honor, the relevant inquiry for the court is whether any funds allocated by the government and then used on housing transforms property into subsidized housing. And that's just an absurd interpretation of the statute. If Rainbow and Gilead received subsidies to install solar panels on the property and were otherwise entirely privately funded, the fact that they then used the subsidies they received to install solar panels to pay for housing costs wouldn't transform an otherwise entirely privately funded mental health treatment center into subsidized housing. That's not the intent of the language subsidized housing, and the legislative history confirms any doubt that this court may have.
Justice McDonald and Justice Mullins.
Well, you've probably somewhat answered my question. I just want to go back to the temporary versus permanent and long-term. And what principles can we look to help define or limit that? In the judicial branch, you know, I know, or when I was practicing, I remember having a temporary assistant clerk who had been there for 12 years. And so I just don't know where we draw a line, or if it is to be drawn, or if it's a question of fact about what's temporary, what's long-term temporary, what's long-term permanent. Help me out with that.
Sure, Your Honor. The place to draw the line is based on the design of the program, right? And the design of the program defines whether that program is transitional in nature or if that program is permanent in nature. There's no design for transition in a mental health treatment center. If it is permanent treatment, then that would not fall within the ambit of the temporary housing exception. By contrast, where there's a transitional aspect to the design of the program, that falls within the definition of temporary.
Counsel, where are you getting that from?
Based on the plain language of the statute, Your Honor, the definition of the word temporary includes transitional. And the design of the program here is transitional as testified to in the affidavit of Dan Osborne and in the program and procedural manual.
Counsel, the affidavit, like most affidavits, is self-serving. And that's the problem I have with the affidavit. I also have a problem with the way you're interpreting the statute and saying it's a plain language of the statute. If it's capable of having more than one interpretation, then what do I do?
If it's capable of having more than one interpretation, then this court would look to the legislative history. Now, counsel for Cromwell argued for the first time in its supplemental brief, and again before this court today in its opening argument, that if the statute is ambiguous or at least plausible, then based on the rules applicable to property tax exemptions, this court automatically rules in favor of Cromwell and does not look to the legislative history. That directly contradicts this court's precedent. In the decision of Sikorsky Aircraft Corp. Versus Commissioner of Revenue Services in 2010, in which this court said that the presumption regarding tax exemptions is a starting point, and this court's goal is to look to legislative intent. Indeed, in that case, the court was faced with finding ambiguous the manufacturing exemption for property taxes. What the court did then was look to the legislative history to clarify that property tax exemption and actually held in favor of the party seeking it.
Counsel, I need to apologize to you and to Justice Mullins. He had a question, and I asserted myself without going to him first. My apologies to both of you. Justice Mullins?
No need, Chief. It's always age before beauty, so I completely forgive you. Counsel, I want to take you back to some of the questions that Justice Doria was asking. And just to clarify in my own mind, I think the statute doesn't say subsidized housing. It says housing subsidized. You agree with that? But even more to the point of what I want to ask you is Justice Doria was asking you, about the Demas money doesn't have any restrictions on it. You could use it for anything. And you gave an example about solar panels. But doesn't the statute also say subsidized in whole or in part? What about the in part language? Why does it have to be all or nothing? If you get, it almost seems like you're saying if there's some subsidized money coming, you have to show that the whole thing is subsidized when the statute says it could be subsidized in part. What does that mean? What does the in part piece of the statute mean?
The in part piece of the statute simply indicates the General Assembly's intent to cover both fully subsidized housing and partially subsidized housing. But it does not change that the programs provided at the property must be housing as opposed to treatment, that the subsidies in the first instance be directed at shelter as opposed to those directed at therapy or at treatment.
But what about the part of the question that was interesting to me was, what if, since there's no restrictions on the money, some of it could be used for housing? And if that's the case, why wouldn't the in part portion of the statute be applicable to subsidizing in part those funds that are in part used for housing?
Because the statute is constructed so that it applies to how Gilead uses the property. And Gilead's not using the property for housing subsidized in whole or in part by federal, state, or local government. Gilead is using the property for mental health treatment. That's the use of the property. The allocation of some government funds toward housing obscures the issue because it decouples the subsidy that's provided in this instance from the purpose of that subsidy in its first instance and the way in which Rainbow and Gilead use the property.
Thank you.
Justice Ecker?
One way to untangle this knot, I suppose, I don't know if it works, but it's what you proposed in your brief. And I think it's the argument that drives the state's amicus brief is a purposive analysis, which is to say you look at what the purpose of the grantor's purpose, maybe the applicant's purpose, but the purpose of the subsidy is. So if it's a housing subsidy and it partly subsidizes the housing or wholly or partly subsidizes the housing expenses, then it's not exempted. And if the purpose is to support mental health treatment, then it's exempted. I mean, could you say anything more about why we should adopt the purposive analysis, whether it's consistent with legislative intent and whether it makes sense? It's not meant to be a rhetorical or easy question, by the way.
There are a number of reasons why this purposive approach, as you've termed it, is the correct one. First, the dictionary definitions provided by both parties inherently of the word subsidy inherently tie a subsidy to its purpose. So it's consistent with the definitions of that term. Second, it's consistent with the way that this court has explained the very nature of subsidized housing in the Lamont decision, which is that subsidized housing is a particular technical term that means housing subsidized by a government entity, funded by a government entity, shelter funded by a government entity, not treatment. Third, it would lead to unworkable results were this court to adopt CROMWELL's non-purposive analysis. Indeed, every charitable organization would have to trace every dime of federal, state, or local dollars received, prove that none of that went to housing costs in order lest it be qualified as subsidized housing. And finally, in the legislative history, the language used by the legislature, and this is available to this court in Rainbow's appendix at RA 4 through RA 19, is that, and though it's something of a derogatory term now, it was intended to cover housing projects. That language is used no less than 15 times in the legislative history in this case. And all of that confirms that the purposive analysis is precisely the type that the legislature intended in this instance.
Justice Dario.
I'm just not sure that isn't circular or at least doesn't or self-defeating, I think, because what beyond the contract, the Demas grant, again, it allows you to use it for housing. So, I mean, at least in part, I'm looking at the purpose and saying you can use it for housing. You say you don't. Tracing, do you have to trace the dollars? I mean, it's hardly unusual. Somebody have to do that in, when you get federal and state and other sorts of charitable grants. Maybe the contract should have excluded housing as something you can use it for. That would be clear. But if you look at anything besides the contract, which allows the housing, you're looking only at the manual and tell me why that's not like parole evidence. That's as far as explaining what the purpose of the grant would be.
Well, we're looking at the contract, we're looking at the manual, and we're also looking at Dan Osborne's affidavit, which states that these are not housing subsidies and the occupants are not receiving occupancy subsidies for the property. But doing so, looking to the design in the first instance, as opposed to the ultimate use of the funds, is consistent with how this court, other courts, statutes, the definitions of the language have interpreted the phrase subsidized housing. And indeed, again, it's consistent with legislative history that was made in response to a court decision involving a government-funded housing development that provided nothing more than shelter as opposed to a range of social services for a particular piece of property. That's the way that the term subsidized housing is defined in all available literature, and that's the way the legislature has defined that term when it initially enacted the amendment, and that's the way this court should apply it in this case. Furthermore, this court should look to the fact that in the second part of the statute, in defining what housing means, the legislature explicitly said that certain kinds of housing don't fall within the definition of the word housing, namely temporary housing for those with mental illnesses. And there should be no dispute in this case that Gilead's use of 461 Main Street falls within the scope of that property. That's clear from the language used by the legislature with the word temporary. Look, Rainbow and Gilead are not disputing that the word temporary and temporary housing can mean short term. Indeed, the legislature provided a catch-all for short-term housing of less than 6 months of duration. But that the legislature provided that catch-all and then provided a number of other uses that are transitional because that are temporary because they are transitional by design indicates that the legislature understood these dual meanings of the type of temporary housing. Orphanages, rehabilitation facilities, mental health treatment centers are temporary because they are transitional by design, not because they are limited in duration. It would be unworkable for this court to provide otherwise. Indeed, it would be unworkable for assessors across the state of Connecticut to decide how long is too long, how short is too short. In CROMWELL's opening brief in footnote 9, it provides a plethora of examples of the types of durations that could qualify as temporary. They range from 72 hours to 3 years. How are assessors supposed to apply a statute that, based on all available indications, if it's only short term and must be duration based, is somehow limited in that fashion? That's not the General Assembly's intent. And it's not because the General Assembly intended to restrict that definition based on the specific types of uses and types and examples used. To the extent there's any doubt in this court's mind, this court need only look to the legislative history of the 2003 amendment. Now, it's worth noting that counsel, in asking this court to look to subsequent legislative history and legislation that wasn't adopted by the court, directly contravenes precedent by this court, which says that reliance upon legislative silence is misplaced. That's the Odell versus Cozy decision, and that's Department of Social Services versus Saunders. There can be any number of reasons that the legislature does not adopt a change in the statute, and to rely on silence is inappropriate. Furthermore, to the extent this court does rely on silence by the legislature, it relies upon that silence when a court decision has been reached and then the legislature takes no action. So, to the extent that cuts in any direction in this case, it's noteworthy that the legislature has not changed the statute since Judge Aronson's decision before the trial court. Furthermore, to the extent that the court looks to post-enactment interpretations of the statute, the only instance in which it looks to that interpretation would be to look at past ways in which the statute has been applied. And as previously stated, Cromwell granted 461 Main Street a property tax exemption for this property twice in the previous instance. But look to the specific legislative history. There, the legislature was designing to cover transitional programs. At 63 and 64 of Rainbow's appendix, one representative, Representative Stillman, specifies that this is intended to cover transitional housing. Furthermore, at RA 77 through 78, it's representatives of the Isaiah 61-1 facility that are testifying that this is intended to cover transitional programs. Indeed, they testified that the subsidized housing component of the statute never should have been applied in the first instance, but to the extent there is any question as to how to interpret the statute, this should cover transitional housing facilities. But it's also worth noting that in interpreting the statute, this court's role is to judge how to interpret the meaning of the word temporary. And based on the legislative history, it's clear that the meaning of the word temporary includes that which is transitional, not just that which is short-term in duration. Indeed, it would be absurd to hold otherwise.
Justice Mullins.
I just have a question for you. You disagree with your opponent's view that this exemption statute should be construed against the taxpayer. And if we get to the legislative history and the legislative history offers us a plausible view that this was directed at transitional housing, but also a reasonable view that temporary means something other than transitional, where does that leave us? Does that leave us in a place of applying this strictly against the taxpayer?
That's correct, Your Honor. I would concede that point, right?
Okay.
If after consulting the legislative history, this court is still unclear as to how to interpret this statute, then it must apply that presumption, much in the way that this court would apply the rule of lenity in a criminal case. After consulting all available means of statutory interpretation, then and only then does the presumption provide otherwise. And that's exactly what this court explained in the Sikorsky Aircraft Corporation decision in 2010. And in that decision, the court found that the plain language of the statute was ambiguous. And then, pursuant to General Statutes 1-2Z, this court consulted the legislative history, found that the legislative history clarified that intent, and then reached the conclusion that the statute provided for the tax exemption in that instance. And the situation here, again, to the extent there's any doubt as to both components of the statute, whether it be the subsidized housing component of the statute or the temporary housing component of the statute, supports Rainbow and Gilead's interpretation. Because in 1975, the only thing that the General Assembly was looking to cover were public housing developments, as they called them, housing projects, government-funded shelter. By contrast, in 2003, the General Assembly wanted to make clear that it was exempting transitional programs for treatment of those with mental illnesses. And so this court can rest assured, based on that legislative history, that there is no ambiguity in this case, and be assured of the result that it
Can I just ask you before you run out of time? You mentioned that the original purpose was sort of housing, subsidized housing projects. If we, I could be wrong, and maybe you've looked at this history, but weren't those considered to be, the idea was that it would be temporary, that those would not be permanent housing?
You mean just by design in
Yeah.
the original inception of those sorts of programs?
Right.
So, Your Honor, the design of those, that was not in the mind of the General Assembly, the nature, this question of temporary versus permanent housing was not in the mind of the legislature, in this case, in 1975. And the only thing that was in the mind of the legislature were shelter-specific programs. It's also worth noting that at RA 17 and 18, Henry Fisher, on behalf of the Connecticut Conference of Mayors, addressed concerns that the subsidized housing exception could be used to apply to other kinds of charitable organizations, and specifically said this is only intended to apply to subsidized housing. So faced with a precise concern confronting this court, the legislature in 1975 said otherwise.
Thank you.
Thank you.
Thank you very much, Attorney Naples. Attorney Doss.
Thank you, Your Honor. Let me start by saying that the word transitional is not in the statute. That's what the plaintiffs are arguing, and that's not what the statute says, and that's important for this reason. Again, we think you look at the plain meanings of the statute, but Your Honor, in 2003, when this statute was first proposed, it first said transitional, and it was only after hearing the comments and concerns about having this apply blankly to transitional facilities did the language change to subsidized housing, subsidized in part or state, in whole or part by state government, and temporary. That word temporary was actually changed to account for some concerns that were raised. And the concerns that were raised were raised by the attorney for the city of Bridgeport, that at the time had two cases pending. Isaiah obviously was one, and the Mary Crosby case. So what changed between, if you look at this from 1975 to 2003, the impetus was a Connecticut Supreme Court case called Crosby versus Bridgeport. And what happened there was it was a determination that the tax exemption didn't apply to that, despite how laudable the program was, because it didn't fit the definition of housing subsidized in part by the state. It didn't fit that concept of when the nonprofit is just being able to use the property. In that case, the nonprofit owned the property, but it started getting used for housing. And one of the things that the Bridgeport attorney testified to, and this is interesting, if you look at the 1975 legislative history, it was then Judge Levine, who was then a legislator, was the one who proposed it. And the Bridgeport attorney said that Judge Levine had agreed with his interpretation of it. Again, legislative history, not a fact, but I'm just providing the color of what was behind it. Keep in mind, in that case, Isaiah was given a $1 million state funding grant. And the average length of stay there, according to the trial court, was 6 months. And that was one of the things that was pointed out to the legislature. And so what the legislature ended up doing is it changed transitional to temporary. And that is why that word becomes significant. Now, if you look at the question about subsidies, they keep using the term subsidized housing. That's not the phrase that was used. It's housing subsidized in whole or part by the state. And there's no question this is housing, because look at the program description. It's called a supervised housing program. And to Justice Dioria's point about no restriction on the use of the funds, A308 of the contract, it's in our appendix, A308 expressly allows it to be used for housing. The treatment that's referenced, both here by the plaintiffs as well as by the state's amicus brief, is on A306, and that's at a different facility in Middletown.
Justice Ecker, then Justice Doria.
What do you do with orphanage? You know, I mean, if we're reading the entire statute, I mean, we do have that catch-all with 6 months. That cuts in your favor, it seems to me. And then we have orphanages.
Yeah, and now two answers to that. You're right, it cuts in our favor, the adjudice generum statutory provision where you read everything in like terms. Here's the thing about orphanages. Orphanages were generally obsolete, so it's unusual that it's there. But if you look at the history of orphanages in Connecticut, the average length of stay dating back to the 1960s was 6 months. The average length of stay with respect to orphanages now we're about 90 days, because the goal was to put people in foster care. Now, here's what I would say about that, Justice Ecker. There's no facts in this record to support that. Here's the point. Every one of these facilities needs to be determined on a fact-by-fact basis. So if an orphanage that was receiving state funds had to go ahead and claim this exemption, I think you would find that you have this temporary usage of it, because that's the general understanding of how orphanages are working. And again, each of these other subparts it ends up consistent with that. We don't have lengths of stays, multiple years, battered women's shelter, orphanages, the catch-all of 6 months. Everything was defined towards this class of entities that was going to be temporary. And to your question about the purposive intent and why you would look to the legislative history to determine what the purpose is. Again, what's unique here is this being a property tax exemption statute. We think it begins and ends with the statute. But here's the thing about why that subsequent legislative history, 2016, 2019, 2020, and I should note the 2020 legislation addressed both the temporary language and the housing subsidized in whole and in parts. It was specifically addressing both issues. What that says is not necessarily what the intent of the legislature was, but that there is a plausible reading that those terms as currently used, temporary means what this town and a number of other towns have read to me. May I take a moment to conclude, Your Honor?
Counsel, you may wrap that up very quickly. Then Justice Doria has a question for you.
Okay, thank you, Your Honor. And temporary means what we explained to mean, and housing subsidized in part and whole or part by the state says what it means, because you wouldn't have the proposed changes if our reading was implausible, because the legislature wouldn't have needed to consider additional language. And Your Honor, I can obviously happy to hear Justice Dioria's question.
Thank you. I'm just wondering if you're overselling the J.C. Penney point. That was a valuation case, right? I just read it, and you used the term itself. The statutes for valuation say you have to furnish evidence to the assessor, and you can see why. In the words of that case, there shouldn't be a do-over in court, because you'd have, millions of evaluation appeals. There's no such language in this statute, or I guess the better question is, has J.C. Penney ever been used in anything other than the valuation context? As far as you need to, you're barred from doing anything more than what you put in front of the assessor?
A good question. It has been used on real property valuations by 2 Superior Court decisions, but you're right. It would be in this context of the exemption. It has not. But what I would note, Your Honor, what's consistent about is J.C. Penney relies on General Statute 1242, and what General Statute 1242 says, the assessor, if they don't have sufficient evidence, they have to make that determination pursuant to their oath, pursuant to 1255A, which requires the reporting of the grand list. They have to make that determination based on their best information. And so what the J.C. Penney concept is if the assessor's making this assessment based on of whether the exemption applies, based on the best information it has, and the property owner doesn't provide information, they're stopped essentially from arguing that the assessor didn't do their job. Because the assessors, if you don't provide the assessor with the information, how are they supposed to make that assessment? How are they supposed to determine whether they're eligible for the exemption? And, Your Honor, I would note that under 1289, it is the assessor's obligation under the statutes to determine whether the exemption applies.
Got it.
Your Honor, may I take a quick moment to conclude?
Very quickly, sir.
Thank you, Your Honor. I just want to say that in conclusion, again, this case begins and ends with the statute. The legislature has this before it. There's numerous times currently pending. If there's going to be a change to the statute, it should be made by the legislature, not by this court. Town assessors require the ability to simply apply what the statute says in order to do their jobs consistent with their oath and fairly apply tax exemptions and ensure that municipal services are equally borne by individuals, that property owners in the municipality. With that, we ask that the judgment below be reversed. Thank you, Your Honor.
Thank you, counsel. Thank you, both counsels. We appreciate you coming in and doing this virtually. People often ask me, does oral argument make a difference? And I always tell them, yes, it does. So thank you for helping inform the court and giving us the information we need to resolve this matter. I will see my fellow justices in the virtual conference room. Take care.